Or maybe they should have gone to Amazon and buy some testicles online instead of just saying, sure, I'll just show you the phone records of a sitting United States senator on the basis of an administrative subpoena. Now, do you have copies of the subpoena applications for
Yes,
these
Senator,
8?
Senator, I can't discuss anything regarding this
You can't
case
even
with
tell me
you.
if you have copies?
I can't discuss any of this.
All right,
with
when are
I'm
you
sorry.
going to, General, when are you going to be able to discuss it?
I can't discuss whether there is or is not a pending investigation,
I understand,
Senator. This
but
was
let's
just
assume
brought to light
if
by
there is a
Director
pending
Patel.
investigation, I don't want this to get swept under the rug, okay? Because I think you're going to get pushback from all quarters. I think the telecommunication companies are going to be all over you like a bad rash because they've got liability here for just turning over these records when they knew what was going on. I think some FBI agents may have some liability here. I think a special counsel might have some liability here.
When I watched Senator John Kennedy explode at Attorney General Pam Bondi during that Judiciary Committee hearing, I felt like I was watching an argument about the rules of our democracy, about who gets protected by the law and who gets bypassed.
Let's suppose that I'm appointed special counsel at the Department of Justice, and I go to the telecommunication companies, the phone companies. Let's single out AT&T, and I say, look, I know you're busy, but I want to see a copy of the phone records of a sitting United States senator. They're not going to just give them to me, are they?
No, Senator, of course not.
In fact, they're probably going to ask me what planet I just parachuted in from, aren't they?
Yes, Senator.
They're going to tell me to come back with a subpoena, aren't they?
Yes, Senator.
Okay. What do I have to show in that subpoena to get those phone records of a sitting? Did I mention it was a sitting United States senator? I can't remember. What do I have to show to get the phone records of a sitting United States senator?
Yes, Senator, there were actually 8 sitting United States
Yeah, I
Senator,
heard that.
and you would
I
have
heard
to
that.
have cause.
I'm sorry, what do I have to show?
You would have to have cause to get the
Good
subpoena.
cause or probable cause?
Probable cause.
Okay. Probable cause, or if it's a subpoena, deuces take them, good cause, to show what?
You would need good cause for a subpoena ducis tecum, and what you would have to show is that you believed a crime had been committed, or there was a possibility of a crime, or that could lead to other crimes. We
By the
frequently, in criminal enterprises, subpoena cell
By the
phones.
sitting United States senator.
Senator, they would have to have believed you were part of a criminal conspiracy, is my understanding.
Would a judge have to sign off on it? On the subpoena?
Yes, Senator. Well, for a subpoena ducis tecum, Jack Smith probably took it straight to the judge.
Now, the phone companies, particularly their general counsel, if they're worried about civil liability, even with a subpoena, to get the phone records of a sitting United States senator. Did I mention it was a sitting United States senator?
Yes, Senator.
The general counsel for that phone company, let's say AT&T, they have the right to seek to quash that subpoena, don't they?
Phone companies frequently do that.
Yeah. And a smart general counsel for that phone company is going to call the sitting United States senator and say, would you like to weigh in on this? Would you like me to quash the subpoena? We're talking about invading someone's privacy here by a sitting United States senator. Could the general counsel for the phone company do that?
Well, Senator, if they believe that a crime could have been committed, they could not tip off the person who committed the crime. Again, I can't comment on details of this particular case.
I'm just asking you theoretically.
I've never seen you commit a crime, Senator Kennedy.
But let's suppose, okay, they didn't want to tip off the sitting United States senator. But the phone company and the general counsel for the phone company, or companies, if there were more than one involved, could say, you know, this is serious as an aneurysm. This is serious as 4 heart attacks and a stroke. This is a sitting United States senator. So general counsel would likely advise the CEO, you need to file a motion to quash. The telephone companies could have contested those subpoenas, could they not?
Hypothetically, yes. I can't talk about the facts of this particular case.
We're talking hypothetical.
Senator, subpoenas are issued all the time through phone companies working with the general counsel.
But they can file a motion to quash.
They could, yes.
Yeah.
In any case.
And if they should have filed a motion to quash, and a reasonable person would have filed a motion to quash, because this is a sitting United States senator, and they didn't file a motion to quash, they would incur civil liability, wouldn't they?
Senator, typically phone companies follow a subpoena from a United States attorney.
I know they do, but they don't have to.
They could challenge it, Senator.
Yeah. And if they don't challenge it, they better have a damn good reason. Right? Right?
Senator, I can't talk about the facts of this particular
This is just
case.
a hypothetical.
In general, hypothetically, Senator, maybe they didn't recognize any of the names of the 8 sitting United States senators.
Hypothetically.
That was a joke.
Or maybe they should have gone to Amazon and buy some testicles online. Instead of just saying, sure, I'll just show you the phone records of a sitting United States senator on the basis of an administrative subpoena. Now, do you have copies of the subpoena applications for these
Senator,
8?
Senator, I can't discuss anything regarding this
You can't
case
even
with
tell me
you.
if you have copies?
I can't discuss any of this.
All right,
with
when
you,
are you going to, General, when are you going to be able to discuss it?
I can't discuss whether there is or is not a pending investigation,
I understand,
Senator. This
but
was
let's
just
assume
brought to light
if
by
there is a
Director
pending
Patel.
investigation, I don't want this to get swept under the rug, okay? Because I think you're going to get pushed back from all quarters. I think the telecommunication companies are going to be all over you like a bad rash because they've got liability here for just turning over these records when they knew what was going on. I think some FBI agents may have some liability here. I think a special counsel might have some liability here. If I were your special counsel and you had appointed me and I wanted to get the records of a sitting United States senator, is that something you would expect me to tell you as Attorney General of the United States?
They better have.
Yeah.
And
Do we know in this instance of the 8 sitting United States senators if they told Attorney General Garland?
Senator, I just learned about this very recently, as did Director Patel, and we cannot discuss the details. I don't know many of the details.
Well, maybe we ought to get Attorney General Garland here. Do you know if the special counsel told FBI Director Wray? Is that something? Let me put it another way. If I were your special counsel and you were the director of the FBI and I'm trying to get the phone records of a sitting United States senator, did I mention it was a sitting United States senator? Is that something that you would expect me to tell you as director of the FBI?
In general, I would believe the FBI would help execute the subpoenas.
Yeah.
To the
Kennedy's line of questioning was blunt and, on its face, simple. If a special counsel can demand phone records for sitting U.S. senators, what legal steps should have been followed, and who knew about it? Those are not technical quibbles. They're central to whether the Justice Department treated elected officials as citizens with rights or as targets to be swept up without usual safeguards. Kennedy lays out the hypotheticals in a way that helps people understand the law. To get phone records of a sitting senator, you don't just stroll in and ask AT&T for them. You need a subpoena, and for records that touch a sitting senator, you generally need to show cause, often probable cause, and a judge usually signs off. The telecom's lawyers can, and often do, move to quash subpoenas if there's a legitimate privacy or legal problem. Those are basic guardrails designed so investigators don't trample privacy and constitutional protections. If those steps were skipped or mishandled, it's not a bureaucratic mistake, it's a potential constitutional problem. That's why what the committee is wrestling with matters beyond the personalities in the room. Recent reporting and the materials released surrounding this hearing suggest that the FBI or special counsel's team obtained call logs for multiple Republican senators during an Arctic frost investigation, a revelation that shocked lawmakers and the public because it raised the question of whether standard procedures were followed and whether grand jury secrecy rules or other protections were properly observed. Whether it was 8 or 9 senators named in different briefings, the core issue is the same. Did investigators follow the law when seeking records tied to members of Congress? Bondi's repeated inability or refusal to answer concrete questions about who saw what, who authorized which subpoenas, and whether telecoms were pressured or simply complied is the kind of evasiveness that eats away at public trust. She repeatedly pointed senators to the FBI or to pending investigations, which is procedurally understandable sometimes, but when multiple senators press the same narrow factual points and the Attorney General keeps deflecting, citizens are left with two possibilities. Either the facts are genuinely sealed and can't be discussed, or the facts are being shielded for political reasons. Either outcome deserves scrutiny. There's also a human dimension to Kennedy's rhetorical device. He frames the law in plain terms that people can visualize. A subpoena duces tecum, a judge signing off, a general counsel weighing liability. That approach matters because most people don't parse legal minutia, but they understand fairness and process. If your phone company handed over your records without a judge demanding them, you'd be outraged. If the same thing happened to a U.S. senator, we should be outraged too, and even more demanding of clear, verifiable answers. That outrage isn't partisan instinct, it's a civic reaction to a potential breakdown in the civil liberties we all depend on. So what should viewers take away? First, insist on process. The specifics Kennedy asked about, probable cause, judicial sign-off, motions to quash, and whether the Attorney General or FBI directors were notified, are not arcane. They are the mechanisms that protect privacy and prevent abuse. Second, demand transparency where transparency is legally permissible. If grand jury secrecy truly prevents immediate disclosure, explain that plainly and provide a roadmap for oversight without violating rules. Third, support robust, nonpartisan oversight. Congressional committees exist to pry open these exact questions and to compel documents and testimony when necessary. When officials stonewall, oversight should escalate in legal, public ways. Document subpoenas, sworn declarations, and, if need be, referrals to inspector generals.